I'm attorney Brenton Callaghan, and this is your Connecticut domestic violence case. The night of the incident. Police respond to the scene. They will separate you and your partner. Officers investigate and decide who is the primary aggressor. It's not always the one who called 911. Connecticut has a mandatory arrest law. If there's a probable cause of domestic violence, someone is going to jail, period. Evidence is collected, like photos, 911 recordings, statements, visible injuries, and you may be arrested, even if your partner says they don't want to press charges. The state brings the case, not your partner. Why only one person gets arrested? AKA the primary aggressor law. Connecticut used to arrest both parties in domestic disputes. That has changed. Connecticut law now requires officers to identify the primary aggressor and arrest only that person. Dual arrests are strongly discouraged and rarely happen today. Officers look at who initiated, history of violence, relative size and strength, defensive injuries, offensive injuries, prior calls to that address, and so forth. The person who called 911 is not automatically the victim. Police make an independent determination. And this matters because the wrong person sometimes gets arrested, and that is something a lawyer can challenge. Family violence crimes in Connecticut. Domestic violence is not a standalone charge. It's a classification applied to standard crimes. Those crimes being assault, first, second, and third degree, disorderly conduct, threatening, strangulation, criminal mischief, and harassment. The relationship between the parties determines the family violence designation. Of course, it can be husband and wife, grandparent or grandchildren, children, aunts, uncles, boyfriend, girlfriend, boyfriend, etc. It can also include ex-boyfriends or girlfriends. Arrest and booking. After arrest, the person is transported to the local police department, processed, fingerprinted, and photographed. Release that night is possible. It is not automatic that you will stay until arraignment. Whether you go home that night depends on the severity of the charges, the responding officer's discretion, and whether you have somewhere to go that is not the shared residence. If you have a friend, family member, or go to a hotel, tell your lawyer immediately, as that matters. If released, you'll be given a date to appear in court the next business day. Missing that date is its own criminal charge. And if not released, you wait in lockup until arraignment the following morning and the officers bring you. Gun permit consequences. Note that this happens fast. Connecticut requires police to seize any firearm in the home at the time of the domestic violence arrest. By law, your Connecticut pistol permit is immediately suspended upon arrest. The suspension happens before any conviction, just the arrest triggers it. The Department of Emergency Services and Public Protection handles the suspension. You must surrender your permit and all firearms. Failure to surrender firearms is a separate criminal charge. Even if the criminal case is dismissed, you must petition to get your permit reinstated. It does not come back automatically. Federal law, the Lautenberg Amendment, permanently bans firearm possession for anyone convicted of a domestic violence misdemeanor. Even a misdemeanor, not just a felony. And for clients who are law enforcement, security, or military, this is often the most devastating consequence of the entire case. Arraignment, the next business day. This is the first court appearance, usually the morning after arrest. A judge reviews the case and sets formal conditions of release. A family relations officer meets with both parties before court, and almost always a protective order is issued. The Fernando A hearing. Request this at arraignment or lose it forever. Connecticut law gives you the right to hearing to contest the factual basis for the protective order. This is called the Fernando A hearing. If your lawyer does not request this hearing at arraignment, the right is permanently waived. You cannot ask for it later. At the hearing, the judge examines whether the facts actually support the level of protective order issued. Your lawyer cross-examines the officer and challenges the evidence behind the order. A successful hearing can result in the order being modified or reduced. This is one of the most critical reasons to have a lawyer before you walk into the arraignment. This is not something to handle on your own. The hearing requires legal strategy, knowledge of the rules of evidence, and skilled cross-examination. Without a lawyer at arraignment, this right disappears the moment court ends. Firearms are protective order. The protective order will contain explicit language prohibiting firearm possession. This is not optional, and it is not a suggestion. The order has the force of law the moment the judge signs it. You must surrender all firearms and your pistol permit immediately, that day. Surrender to a local police department or as directed by the court. If you go home and there are guns in the house, they need to be gone before you walk in the door. Keeping firearms while under a protective order is a federal crime under 18 U.S.C. subsection 92 G8. Adding federal charges on top of your state case, this federal firearms charge carries a mandatory minimum sentence. Even if you think the order won't last, even if you think the case will be dismissed, you cannot possess firearms while the order is active. The risk of holding on to your guns for even one day is not worth it. Lastly here, if you have a full no-contact order and cannot return home, you are entitled to a one-time police escort to retrieve your essential belongings. You arrange this through the local police department. You get one visit. Plan ahead and bring someone to help you carry things. Take what you need: medications, documents, clothing, work essentials. Once you leave with that escort, you cannot go back for any reason. It does not matter if your partner calls and invites you back. It does not matter if your partner says the order doesn't bother them. It does not matter if you left something important behind. If the protective order is still active and you go back, you are committing a felony. Full stop. The only way to go back into that home is a court order modifying the protective order. The protective order and why the judge controls it, not the victim. Can our partners drop the protective order? No. The protective order is issued by a judge, not by the victim. Connecticut law gives the court, not the victim, authority over the order. They believe victims in domestic violence situations are often under pressure, fear, or emotional influence from the person who harmed them. The law exists to protect victims from being coerced into dropping protections prematurely. The victim can request a modification, but the judge decides whether to grant it. Even if your partner tells you it's okay to come home or be in contact, if the order is still in place, you are violating it. Again, only a new court order can change an existing court order. There are 3 levels of protective orders. 1, a full no contact. They cannot call, text, email, or go near the victim. 2, a residential stay away. They can contact but cannot go to the shared home. And 3, a limited partial protective order. They can have contact but no threatening or harassing behavior. Violating the protective order. Violating a protective order is its own criminal charge. Criminal violation of Protective Code, Connecticut General Statute, subsection 53A-223. It is a Class D felony carrying up to 5 years in prison. It is charged in addition to your original case, not instead of it. So now you have 2 cases running at the same time. Common violations clients don't realize are violations: texting, "I love you," or "I miss you," having a mutual friend pass along a message, showing up to pick up the kids without a formal custody order allowing it, responding if the protected party contacts you, any social media contact, like DMs, follows, etc., and going back to the home, even when invited by your partner. Judges take violations extremely seriously. Bail is often revoked and jail becomes far more likely. There is no "they started it" defense. The order applies to you regardless of what the other party does. Children in the home. As established, if you shared a home and get a full no contact order, you cannot go home. Children may be subject to separate DCF, Child Protective Services, involvement. Family court and criminal court run simultaneously and separately. Divorce and custody proceedings are not handled in criminal court. Family Relations Division. Every domestic violence case in Connecticut goes through Family Relations. Family Relations officers will interview both parties. They prepare a report for the judge with recommendations. They can recommend counseling, anger management, or diversion. Court process. After arraignment. There will be multiple court dates. Do not expect this to resolve quickly. In addition, there will be pretrial conferences where the prosecutor and defense counsel negotiate. The evidence is reviewed: 911 calls, body cam, officer reports, medical reports, prior history, and the victim's wishes are considered, but do not control the case. The ways the case can resolve. Number 1, Family Violence Education Program, or FVP for short. A diversionary program: complete the classes, case gets dismissed. This is not available to everyone. Prior use, severity of the charge, victim objection can disqualify you. It does not equal admission of guilt. It is available once every 10 years. Number 2, plea agreement. Plead guilty to a reduced charge. It may involve probation, counseling, fines, community service. It creates a criminal record and could affect employment, housing, immigration, and gun rights. Number 3, dismissal. The charges are dropped. This happens when evidence is weak, the victim is uncooperative, or a strong defense exists. The prosecutor still controls this. The victim recanting alone does not guarantee dismissal. And lastly, number 4, trial. A jury or court trial. The state must prove guilt beyond a reasonable doubt, and the victim can be subpoenaed to testify even if they don't want to. Collateral consequences. Employment. Arrest records are visible. Some jobs require disclosure. Immigration. Domestic violence convictions can trigger deportation or visa issues. Professional licenses. Attorneys, nurses, teachers, and contractors may face licensing boards. Housing. Landlords run background checks. Firearms. On the federal level, the Lautenberg Amendment permanently bans gun possession for any domestic violence misdemeanor conviction. No exceptions, no restoration at all. Firearms on the state level. Connecticut pistol permits suspended at arrest must be actively petitioned for reinstatement even after a dismissal. And for the family court, the criminal case outcome can affect custody and divorce proceedings. Case ending. Dismissal after FVP completion is the best outcome. There's no record. Noli prosequi, aka nollied, the prosecutor declines to pursue, not a conviction, but stays on record for 13 months. Acquittal at trial is a not guilty. The case is over. Conviction, there's sentencing, possible jail, probation, fines, and a permanent record. After dismissal or nollie, expungement may be available. That is erasure of the record. Lastly, gun permit, reinstatement. This must be petitioned separately. It does not happen automatically. Some final thoughts to highlight. Your partner does not control this case. The state does. Do not contact the victim if there is a protective order. Not through friends, not through social media, not by responding to their texts. Do not talk to police without a lawyer present. Surrender your firearms immediately if required. Do not hide them. Everything said on jail calls is recorded and will be used against you. A domestic violence arrest moves fast. Hire counsel before your first court date if at all possible. And that's it. Once again, I'm Brenton Callaghan with Ruane Attorneys. If you're facing charges in Connecticut, give us a call for a free case evaluation and we'll tell you how we can help.